Okay, so hi everyone, welcome and thank you so much for joining us today. I just want to note to say that issues relating to violence against women and girls will be discussed. So if you need to take time out, please do. A recording of the session will be shared on the Centre's YouTube channel and our website in the coming weeks, so you can always catch up. And with that, I think I'll begin. So in today's seminar, we're delighted to welcome Raquel De Haro. She's a PhD candidate at the Centre for Law and Economics at ETH Zurich, an international visiting fellow at the Centre for Protecting Women Online, and a visiting scholar at Columbia Law School. Raquel's research focuses on digital regulation, particularly platform governance, online safety and privacy, with a focus on tech-facilitated violence against women, and she's also admitted to the Spanish bar. If you have any questions for Raquel, please submit them using the Q&A function and we'll ask them at the end of the presentation. So now I'll hand over to you, Raquel.
Perfect. Yeah, thank you so much for the disclaimer and for the introduction. So yeah, I decided to talk about the text that I wrote when I was visiting the Center for Protecting Women Online. I wrote it with Olga Juras, and it was published in the EU Law Live weekend edition. It's a European law kind of journal and podcast as well. And the title we chose is The Promises and Perils of the DSA in Tackling Technology-Facilitated Violence Against Women, because, and we wanted to talk about the promise and also the perils, because it's actually a very innovative and can be a very useful tool. But as you will see, there are structural issues that maybe don't allow the law to shine as it should, especially regarding online safety for women. So basically, that is what let me pause the slide. So this is a bit what we will cover. I will briefly introduce the law in case someone is not familiar. Then I will talk about structural issues that are not only happening in the DSA, are happening in general in all digital law, especially when we talk about technology-facilitated violence. And it's like a bit of a global phenomenon and like issues that we have with that. And then DSA-specific perils. And I want to mention again that it's perils and not things that necessarily are being materialized at the moment, but it's things that we see that in the future can be more like problematic or that will need further guidance at some point. And then we can conclude all together. And of course, feel free to ask as many things as you wish. So first, I wanted to bring the perspective of this debate on that every time that we talk about digital law, it's always either regulation or innovation or content moderation or free speech, and these concepts are framed as if they cannot coexist together. And in this talk, I think I will try to make claims and show how some of the free speech and innovation narrative is also being incorporated more and more in the European Union, and how this is actually dangerous when you don't have the nuances in the speech. This is a very common, let's say, narrative in the US, and I see how it's gaining traction in the EU. And sometimes I think like it's scary and we need to start naming things, especially to get enforcement at some point of the law. So just to do like brief overview of the law, the main goal of the Digital Services Act is to try to get a safe, predictable, and trustworthy online environment. And to do so, it incorporates the main obligations of the previous e-commerce directive that shield platforms from liability for user-generated content when they are not aware that this content exists, and therefore there are prohibitions of that there are no obligations on general monitoring, for example. So this is also, again, connected to response to people who claim that this is a censorship law. But it amplifies all this previous framework, adding some due diligence and transparency obligations on intermediary service providers. It adds these obligations, sometimes distinguishing by type of provider and sometimes also distinguishing by size. Size-based regulation is an important thing that we will discuss later, but just so that everyone knows what I'm talking about, when I say VLOP, it's a very large online platform, and those are 40 platforms with more than 45 monthly million users in the EU. If you're wondering exactly which platforms are those, I put them here in this slide. StripChat is a also like type of adult content platform that was removed as a VLOP, probably because they could prove that they have less than this amount of users. And WhatsApp was the latest incorporation into into this list. And these companies are designated by the European Commission, and as such will have specific obligations based on their size. Important to say as well that the other term I'm using, it's a very large online search engines. And in that case, we have Bing and we have Google search. And then the law entered into force fully for all platforms in February 2024. And at some point, it can even sanction up to 6% of the annual global turnover. And in case of repeated infringements, it could even mean the potential temporary restriction of the platform or the service in the union. So this is a bit the introduction of the law. So why we talk about the promises of the DSA and why we had so much hope in a way in this law, it's because in Article 34, it talks about systemic risk. And in point D, it actually mentions gender-based violence as one of the systemic risks. This is not detailed enough, as you can see. And if you read points A to D, it's very broad, and we will probably need further guidance on what specifically falls into the category of a systemic risk. But it's interesting because the DSA is the only law of the digital package where gender-based violence features much more prominently. It doesn't happen in the GDPR, it doesn't happen in the AI Act, it doesn't happen in the DMA. So in that sense, it's actually, this is a good sign in a way. And the DSA is a very innovative law that has this bottom-up approach, which relies a bit on delegated enforcement, which kind of assumes that the authorities don't have the capacity in a way to control and enforce everything that should be monitored in the market. So they rely on specific institutions like trusted flaggers, like vetted researchers, like civil society, like ODS bodies that I will later explain what these are. And they will also help in a way point to what are the issues that are happening in terms of online safety in Europe, what are the connections, and basically like scrutinize what platforms do. And I would like to talk more about the promises, but I feel like we need to talk about what are the dangers. There are many good things about the DSA, but one of the main issues that I still see with this law is that first, the burden is still on users. And this, when you talk about technology-facilitated violence against women, is still, in a way, re-victimizing because people suffering from certain forms of tech-facilitated violence will have to watch content that has been harmful again. They will have to be proactive in claiming and going to one party. And when the platform doesn't respond, then it doesn't respond, and taking this content to another entity like an ODS body or the digital service coordinator in their countries. So, and this happens not only with the DSA, it also happens, for example, with the Take It Down Act, which is a recent act here in the US. So this is, I would say, a structural issue because it's clearly not only a matter of the DSA and not only happens and affects technology-facilitated violence, but we have to see also the impact that this has. And then the other thing I wonder is that it's very interesting and innovative, the approach of the law, but it relies so much on civil society and on like external actors that are not directly the enforcer or platforms. And I wonder basically what happens when this bottom-up model of enforcement what happens when the bottom is overworked or underfunded, which is what is happening globally right now, that civil society is really struggling. And if we don't have a strong civil society that can actually implement either like legal policy, technical measures, and that are strong enough in the terms of lobbying for or pointing to the authorities, to the regulators, what are the issues that are happening right now in terms of online safety, then some of the tools of the DSA, which are very innovative and interesting, become meaningless in a way, or not meaningless, but like, let's see how they are implemented if we keep like defunding civil society. And then it still relies on a reactive framework. Like much of the focus is put on the users' proactivity. And then what happens is that we realize we didn't include some of the things that have happened in any of the laws of the digital package. We still focus too much on the user side, on like criminalizing conducts, prohibiting conducts. And I think sometimes we should like look upstream in this chain and check better for the responsibility, not only of the platforms deploying the products, like it happened with the Grok scandal. I'm sure everyone knows about it. Grok is this AI chatbot embedded into X that can also be accessed independently on the website, and it generated millions of images of non-consensual, basically sexual deepfakes, and also of minors. And there are some studies that even pointed to how also Apple and Google were profiting from other types of like nudifier apps that were in their app stores, and what is their responsibility? Because we talk a lot about the Grok scandal and X, but this is actually, as you probably know, this is a bit systemic, and we've seen in the latest months so many cases of like nudifier apps being reported and so many studies. I didn't want to extend too much on like the details because I feel like in this setting everyone knows about the cases. So yeah, the DSA contains preventive rules, which is interesting, but then, for example, one of the preventive rules could be like the risk assessments that very large online platforms have to do before deploying functionalities that are likely to have a critical impact on the risks identified. And as we have seen, gender-based violence is one of the systemic risks. And now we wonder, did this happen with Grok and X, for example? Did they actually checked or thought of that this could be actually a risk? Like, we don't know. What we know is that at the moment there's investigations going on, and let's see what happens with that. But it's actually interesting that the law has these preventive measures, but we don't really have means to to audit things before they happen. And this in part comes from the fact that we don't have this gender equality perspective in general embedded into how platforms are designed, how platforms create their own risks assessments, how the regulator thinks and operates. And so that's why we need, in general, having like gender expertise everywhere in society, because then things like that can be foreseen, because it's nothing new. Like academia and feminist civil society had been warning about the dangers of deepfake abuse and the systemic risk this was posing since at least 2017. But only last year, late 2025, and this year, 2026, we've started to see the big scale impact, and only then we have reacted. So at the end, even if we have these preventive measures, they are proving a bit like, at least so far, inefficient. And I don't want to be too harsh on the law because in a way, it's also a very recent law, and there are so many guidelines that still further need to be developed, but it's, I think, interesting, right? And on this, as we can see, is again another reaction. I know some people say that this is not a reaction to the Grok scandal, but I think we cannot claim causality, but it's clear that this happened before this scandal, and then there was a global regulatory effort to tackle deepfake abuse in particular, and that is when the Digital Omnibus on AI introduced a new prohibited practice in the AI Act, and this prohibited practice is actually relating to this type of content, or creating this type of content, or deploying this type of services in the EU. So we have that. And then moving more to DSA specific perils, first I will mention something on the terms of service. Then I will talk again about the general lack of expertise in bodies around the DSA on violence against women and girls. What are the issues of size-based regulation? And then I will cover briefly vetted researchers. So talking about the discretionary application of terms of service, I have to disclaim, I'm doing research specifically on this topic, but I have not published the results yet. So that's why I wanted just to bring the overall perspective and mostly qualitative data. But one thing that I found interesting is that one of the claims, or the slogans that was relatively common to use when the DSA was being negotiated was, what is illegal offline should be illegal online. And that is interesting because actually when you check one of the tools that the DSA has created to improve transparency, and this tool is the DSA Transparency Database. In case you're not familiar with this database, it's public, it's run by the European Commission. You have a user interface that you don't require any sort of technical knowledge, but if you want to access the decisions like from, I think, the last 6 months or more, you need access to the API, so a bit of technical knowledge. But this would be like the summary of the information that is reported there. And basically, online platforms have to send to this database all the content moderation decisions they take in the European Union, and then they disclose specific information. I will show you an example right now. But if you read here on most reported violation, you would see that the first one is other violation of providers' terms and conditions. So, and there are studies claiming that even like around 99% of the moderation happening in this database is actually clicking on violating terms and conditions. So it's interesting that the law claimed what is illegal offline should be legal online, but then the most selected choice to moderate content is on terms and conditions. And this is not necessarily bad in itself, because of course there is an overlap between what terms and conditions prohibit and what is legal or illegal. And that's what we are seeing. But what happens with how this tool was designed? So as you can see, this is how, if you use the like user without technical API interface, you will see the statement of reasons like that. And basically it will be platform name, Mil Anuncios is like a Spanish marketplace, visibility of the restriction, type of account that was moderated, facts and circumstances that were relied to take that decision ground. And here we can see content incompatible with terms and conditions. And then they should refer to contractual ground. And then this question at the end, there are more after, but like this question, is the content considered as illegal? Yes, that is actually interesting. But then you look at other type of submissions, and is the content considered as illegal? No response. Why is that? It's because this question in particular is voluntary for platforms to fill. So it turns out that if you want to check some of these like patterns, it's difficult, if not impossible, because you rely on platforms voluntarily disclosing this content. And this becomes even more problematic when we're talking specifically about cyber violence against women categories as they are defined in the DSA Transparency Database. Why? Because, for example, I checked 2 days ago the open database. I didn't access it through the API. But here you can see on the top number of statement of reasons. I only filtered by cyber violence against women. So you get all these numbers submitted in only, I think, the last month. Then what happens when I filter for all the categories that are voluntary for platforms to click on? And that would allow you actually for a meaningful analysis, because in the first, like this example of Pornhub, it's cyber violence against women as a broad category, which is cool. It's interesting to know that. But then it's not the same. Or like if you want to do a meaningful study, you need to know if we're talking about non-consensual intimate material or cyberbullying or cyber stalking or cyber harassment. And actually the categories are quite well defined. And I know they were informed by the European Institute on Gender Equality. So in a way, it's like, it's a powerful tool, or it could be a powerful tool, but by how it's being implemented, leaving so much discretionary decisions to platforms that mostly automatize the submission to this database, it becomes more useless, at least in terms of scrutinizing what's going on with technology-facilitated violence against women content. As you can see here, I filtered for all of these, and I clicked on all of them, and then the same amount of data reduced to only 430. Of course, I'm not making any like systemic claim, because this is just the information reported in the last month. It could be different if you analyze more data, but I think it's still interesting to show how when you leave things voluntary, it's understandable that platforms will not fill the information because they don't have to. And then you rely too much on their free will of like collaborating on that, or on their automated systems being programmed to actually fill these categories. So that is one issue. And then I wanted to highlight some examples that I found. They are qualitative, but I thought it would be illustrative in case someone it's the first time that they hear about that. What do we mean when we say discretionary application of terms of service? It's that platforms have a policy, for example, adult policy, sexual content policy, and it's applied arbitrarily. And again, I'm not making causal claims. This is just qualitative information, but I think it's illustrative of what happens behind. And that's something I'm trying to look in my research. For example, this is the example. Aquafit is a company and they do like fem health products. And they wanted to advertise, I think it's an intimate cream on Google. And they were using sex pain as a word, which is in itself problematic because sex shouldn't be painful, but okay. So like we also have to frame all this in this context. But Google delisted the advertisement using their own policies and told them that if they want to advertise this product, they have to use the technical word, which is apparently vaginismus. And the company was saying, but if you looked on how frequently each term is searched, the word sex pain is much more looked for on Google than the word vaginismus. So in the end, this creates a disproportion between the content and how the platforms are applied to products related to female health, female sexuality. And then also on the other side, like how this content is amplified, because it's like they profit from both sides. On one side, it's like there's in a way more like arbitrary moderation of certain content, but then when there are like some cases like we saw in Grok of like massive cases of deepfake sexual abuse or like non-consensual intimate images, everyone has access to those images. And those are like, take some more time to be moderated. So those imbalances are at least interesting. And this also led some startups working in this field to write a letter to the European Commission claiming digital censorship. So that's also interesting. And just to provide one more example, as you can see here, this is also from the Center for Intimacy Justice report. When used, and also qualitative information, but morning erection on YouTube, public no restrictions and monetization is on, as you can see on the top of the slide. And then all the other videos that talk more about things related to women at the end, like orgasm for women, G-spot, whatever, limited monetization and also restrictions into where they will show this content. It will be interesting to see if this happens at scale, because most of the studies are qualitative. And then, of course, when you present this information in specific forums and in front of specific audiences, they will tell you, but this is not like, this is qualitative information, this is not systemic. How can we prove that this happens at scale? So I encourage everyone to like write to me if you have technical expertise to go deeper into these topics, right? And then another issue, as I was already introducing before, is about the amplification of content. And one day I was reading policies from Model VLOPs, and I came across this interesting sentence in X that says, freedom of speech is a fundamental human right, but freedom to have that speech amplified by X is not, which was in a way like interesting for me that they even include that. And I for sure agree with this sentence. But the DSA also has rules about amplification of content, mostly through recommender system transparency. And basically what they do is ask for platforms to explain in their terms of service the parameters they use to recommend systems and how they offer, like how they balance what's the weight of these parameters, and also what options the user has to influence those. Here, the regulation in a way is again broad and vague, that I'm not sure we can translate that into meaningful application, because it's relatively easy to comply with that as long as they include it in the terms of service and so on. They should be fine. But the thing is that how do we audit that? And this also makes me think of the role of transparency and the use of transparency as the main tool in digital law, when again, we rely so much on the disclosure that the companies will do. And we don't have so many tools and means to actually check that these disclosures are aligned with what happens in practice. And here I have another example. One other article, what says is that very large online platforms have to at least provide a different option that is not based on profiling. This means, for example, if you have a feed on Instagram, you should be able to access an option that is not based on your personal characteristics and targeted to you. So you could pick, for example, chronological feed, and then you only get the information in order. There are other types of feeds that you can choose. But a Dutch court already investigated Meta, because apparently when users were clicking on this chronological feed or like non-profiling version of the feed, these options were not sticky, which means that every time the user would enter the platform, they would have to click again on these options. And it's not that they are very visible in the app. You really have to look a bit for them, which is also interesting in terms of deceptive design and how like design interface. And there are rules in the DSA about that too. So yeah, now I will move to the next critique, but here I think you can see again the connection between like the structural opportunities we missed when we regulated the DSA like that, and how they are being implemented in practice, or how this can become perils in the future, or we need further guidance at least on that. So then when I talk about lack of expertise, it's because I have to say, I think it's getting better. And I know personally some of the people who have created out-of-court dispute settlement bodies. In case someone doesn't know what this is, those are private entities that have been created through the DSA that basically give the users a recourse when they are subject to a content moderation decision by a platform and they disagree with the resolution, that they can go to ODS bodies to kind of appeal this decision. Now, the decision of the ODS bodies is non-binding, and platforms have to assume the cost of the fee, and they pay directly to the ODS bodies, so it's free for the user. This, in a way, has also other problematic things. I don't think it's fault of any ODS, but dealing with some forms of technology-facilitated violence against women content, like non-consensual images, what it's like traditionally called revenge porn and so on, like very sensitive material, is tricky, can again be re-victimizing. You have to have specific channels to protect this information technically. And the thing is that ODS need to check specifically the information to be able to take a decision. So they need to have specific means and people equipped and with gender perspective to deal with this content, because I think it's really more sensitive than maybe like some tweets or checking like written messages, right? And then what do they do with this content afterwards? How do they treat it, and so on? So what I see apart from that, but I think this is getting better. We're going there. This is all a new thing created by the law. At first, the ODS were not giving advice on technology-facilitated issues, in particular non-consensual image sharing. So this was de facto creating a hierarchy of harms between someone being I don't know, bullied online, that would have this means of recourse. That, of course, it's to be seen if platforms really implement these decisions because they are non-binding, but at least it's another tool, right? And you couldn't do that if you were, for example, a survivor or a victim of some types of non-consensual image sharing. Now I see that I checked yesterday, and I think there are 9 ODS bodies in Europe, and 5 of them are actually providing services along these lines. So I think it's getting better, but still not all of them provide those services. And then also it depends on the platforms, because since the business model of ODS is based on platforms paying the fee, and we know in Europe, like which platforms are more willing to cooperate and which ones don't. If you happen to have the bad luck of these images being disseminated in openly non-cooperative platforms with the regulator and with the institutions, then ODS bodies, logically, they don't provide the service with this platform, because they know it's like they cannot get the revenues. Yeah, here's where the regulator should really signal to the companies, you have to comply with this, you have to collaborate with ODS, and if not, maybe we should rethink how we think about this system. Maybe it should stop being voluntary, some of the parts. Maybe it could be classified, the lack of continuous ignorance of the resolutions of ODS, or lack of response or lack of collaboration. Maybe it could be classified as a systemic risk at some point. So here's why we need also like better guidelines. But again, this law is 2 years old, so it's very early. But this is somewhere like we need to be careful on how all this will be implemented to ensure that at the end we're not creating like a hierarchy between different types of harms. And here I wanted to mention the same issue that happens with violence against women happens with languages. They only provide at the moment services to moderate content that has happened in specific languages, the biggest languages in the EU, basically like French, German, Italian, Spanish, and others, of course. But also I wonder what happens with all this content that doesn't happen in any language that is official in the EU, but that is spoken by millions of people and happens in the EU. We will need to see how we deal with this content in the future. And I'm talking here about Catalan, about Euskera, but also about Arab or Turkish or so many languages that are spoken by European citizens and are not official. And therefore, this means of redress, they cannot access to them at the moment. Hopefully in the future they will, but at the moment it's what it is. So, and then moving to one of the biggest, I think, failures in a way that we saw after Grok scandal mostly, is that micro and small enterprises are excluded from most of the obligations of the most or many of the obligations of the DSA. And I understand that because probably the reasoning behind that is like those are small companies, they don't have the capacity to develop this comprehensive compliance mechanism, because at the end it's not only the DSA, it's the DSA, it's the GDPR, it's the AI Act, it's like there's so many things. But at the same time, regulating only like that and like assuming for sure that this narrative on regulation affects innovation is harming, particularly in this case, women's online safety. Why? Because as you can see, or as you know, probably most of the forums and apps and places where gender-based violence online is most rampant would actually qualify as micro and small enterprises because they don't have the number of employees and the revenue threshold required. So then we wonder, like, okay, what happens then? Like, if we remove the out-of-court dispute settlement, the reliance on trusted flaggers, the protection against misuse, the prohibition of deceptive or manipulative interface, if they don't have to contribute to the ad repository, if they don't have to ensure recommender system transparency, if they don't have to ensure all that, and we know that most of the hate against women is created in this type of forums that we can all name. And from there, usually it translates and it travels to Instagram or Facebook or bigger platforms. Then what? Like, again, this is placing the burden on the user because they will maybe see the content deleted in some platforms, but not in others. And that's tricky in itself. So yeah, this is, I think, one of the biggest issues that has ignored the specific nature of harms that are traveling online. Yeah. And finally, connected to also the point I said before about the ODS bodies is also vetted researchers framework. This is also an interesting and it has a very good potential, this provision, because it basically grants access to non-public data to researchers. As you can see, this is still being implemented, and at some point the Commission, I'm hopeful that they will publish like how to get this data, what platforms are collaborating. They will also publish what type of data can be asked or not, and so on. But then my wonder is, okay, this is deeply connected to what type of research gets funding. And we know that, especially in some countries more than others, but in general, there's been a global defunding of research related to gender equality offline and online and gender studies in general. So again, if vetted researchers will be granted based on what research they are doing, and we cannot ensure representativeness in the study of all the systemic risks and in study of all the online harms, we risk, again, having an over research and an over representation of things connected to, I don't know, electoral interference, democracy, and other topics that are widely, misinformation, other topics that are widely studied, without actually acknowledging that these topics are deeply connected to online violence against women, and we are frequently ignoring them. And this is basically my main conclusion that I wanted to bring today, is that we have to, like, every time we get a chance to speak about democracy or like electoral interference in abstract terms, we really need to make sure to mention that when we talk about deepfakes or when we talk about democracy, like in the context of online world, the disproportionate impact is on women and minorities. So we need to mention that, and we need to study that as part and as very connected to this problem, and not just talk about deepfakes as abstract thing without actually acknowledging that even in 2019, the European Parliament already estimated that most of the deepfakes are actually sexual deepfakes, non-consensual, and depicting women. So it's not useful to study a lot deepfakes without actually acknowledging the disproportionate nature that this tool has on women. So I think that's very important as a conclusion. And just to highlight how frequently we forget or we don't mention things as technology-facilitated violence, I wanted to bring the Russ Media case. Not sure if you will know about it. I'm not an expert on this, but this case basically, Russ Media is like an aggregator, like an online marketplace that owns another one called public24.ro. And there, someone actually published prostitution services with the image of a woman and a phone number, which is in itself like non-consensual image sharing, is also doxing, and is also, of course, technology-facilitated violence against women in general. And this case was actually very interesting. It arrived to the Court of Justice of the European Union because the big discussion was between the interplay between the GDPR and whether Russ Media in this case was a controller of the data and the obligations in the e-commerce directive before and now in the DSA. And this, I told you, liability shield that platforms do not have this general monitoring obligation. So this is the big debate, and all the, this was a huge case because the positioning of the court is at least interesting, but many scholars from all over, from the US, from the UK, from the EU, I saw them studying and talking and analyzing this case. And to my knowledge, I didn't see a single one actually framing this case as something that it is. It's technology-facilitated violence against women. Of course, it's also platform liability or like intermediary liability. It's also GDPR, but it's also that. And we don't name it. So if we don't name it, it doesn't exist. And then the problem looks smaller than it actually is. So this leads to my last conclusion, basically, that we have powerful tools in intermediary liability to tackle that. We, for several reasons, cannot use them enough, or they are not efficient enough. And then we keep over-relying on legal systems that are, by default, not really designed to tackle this type of content. And this happened also with copyright. I know there are some copyright experts in the audience because I sent a link to them. I wanted to know their opinion. I'm really not a copyright expert, but I know this, and I wanted to bring this study just to finalize. If platforms keep treating content, when you report content through copyright and they react and they remove it, you as a victim, as a lawyer of a victim, as an NGO, will recommend people to keep using those systems, which is fine. There's nothing wrong, and probably there are copyright implications on that too. But and this study is basically a Michigan. It was done at the University of Michigan a couple of years ago, and it's a different legal system because it was based in the US when they didn't even have the Take It Down Act. But basically what happened is that they created AI-generated images and uploaded them on X, and they reported half of them through the policies of the platform and half of them through the copyright law, in a way. And guess what? All the images that were reported through copyright means were removed from the platform the first 25 hours since they were posted. And all the images that were reported through non-consensual policies of the platform were still on the platform 3 weeks after they were uploaded. So this tells us a lot about what means do we actually have to tackle that. And with that, I will just finalize with this reflection by Marianne Franks, from her book Fearless Speech. And she says, big tech companies and user-generated content platforms in particular constantly invoke free speech, fostering the perception that they are essential to it or even equivalent to it. In the process, we lose the distinction between the speech a democratic society should protect and the speech it should promote. So yeah, that's it. Thank you.
Thank you so much, Raquel. There is so much there to digest. It was so interesting. So I encourage everyone and remind everyone to please send your questions in through the Q&A function or drop them in the chat, whichever one feels easiest, most accessible for you. Listening through, there's so much that we could talk about. So a lot of what you said feels very familiar, especially within a UK context as well, within a UK regulatory context and everything that we're faced with at the moment in terms of the promises and perils. But I want to jump back to the start. So there's a growing expectation that civil society organisations will identify harm, support victims, monitor platforms, and contribute evidence to policymakers. So do you think digital regulation is becoming overly reliant on civil society to compensate for gaps in state and platform accountability?
In a way, yes. But I think it's also like these laws were negotiated and like happened in a different context that we are right now. And perhaps we were too naive to believe that they would pretend to be compliant or willing to collaborate forever. And for example, all these big changes in the content moderation policies of platforms happened early 2025, I think, that they openly, it started with Meta and then the other big tech followed. So before that, at least there was the assumption that they were willing to collaborate. And I think that this narrative of innovation kills, digital regulation kills innovation was not so deeply entrenched in like the public debate, at least in Europe. I think this is a topic, I know this is a topic in the US all the time, but I feel like right now it's really gaining traction in Europe. And for this, I want to mention the work of Professor Anu Bradford from Columbia. I think she's doing a very interesting work in exporting the good things of the digital law to the US to dismantle these narratives. And actually, many of the ideas on how digital regulation is really not hurting innovation come from her. So I wanted to also like acknowledge her.
Thank you. I guess that leads me on to thinking about whether you think then, maybe as a further conclusion, whether you think that the implementation of the DSA has genuinely changed platform behaviour in a meaningful way, or do you think we are seeing kind of mostly compliance driven? Yeah.
That is interesting because with the GDPR, for example, we saw there's a lot of empirical research documenting how the first years after the GDPR, almost no websites had actually implemented the cookie consent notices and like the accept button and reject buttons and so on. And they were using dark patterns and so on. I feel like I have the intuition, but again, I don't have like the real conclusion yet. I hope to have it when I finish the PhD, maybe, hopefully. But I have the intuition that with the DSA, we risk having the opposite, an apparent look of compliance, because yes, platforms are submitting the statement of reasons to the DSA transparency database. They are actually mentioning the things they have to mention in the terms of service and so on. But it's in a way meaningless, because if we cannot audit that what they say is the truth, then what's the purpose of having all these disclosures? That's why we need like really, I think the regulator itself needs to include technology to oversee all that. And civil society and academia need to have multidisciplinary teams that can identify the sociological perspective, the legal perspective, and also the technical perspective, and work all together.
It kind of, over transparency, it lacks accountability within it sounds like. Yeah. And then I guess You also spoke about risk prevention and mitigation that's covered in the law. So much of the discussion around safety by design focuses on kind of technical solutions and risk management processes. So how do we ensure that safety by design also doesn't become another compliance exercise within that, but instead kind of genuinely responds to women's lived experiences?
I think regarding to technology facilitated violence against women, we probably need less voluntary guidelines and more compulsory guidelines. Like there are things that if have been proven not to work, we need to make them compulsory at some point, because there's no other way that platforms will internalize these costs they are causing in the digital world, right? And I'm not saying the copyright system works perfect, but it works better. And like, it's in a way sad, or I don't know, interesting, that when you upload an illegal or like counterfeit good on Instagram, it will be detected easier and faster, and the content will be taken down before that if someone uploads a non-consensual sexual image of you, right? I'm not saying the other is not important, but like maybe, and the difference is probably the lobby behind that at the end. And it leads again to the defunding of civil society and people who work in digital rights. Like, it needs to be a strong sector for this to work. The same way that copyright works better because there are strong brands with monetary power behind.
So do you think it's about needing, so then for me, that kind of raises the question, is it a dedicated kind of regulatory response guidance specific to TFVAW that's mandatory? Or is it that we need to consider, is it that we need to consider how we embed kind of gender-based harms or gender equality across all aspects of digital regulation so that we get the...
I think both, probably. Like the fact that Olga Juras always says that, like the fact that the gender equality features much more prominently in specific tailored directives to only talk about criminalization of specific conducts, and not in the AI Act, or not on the GDPR, or not on the DSA, sends this message that these fields are completely separate. And as long as we keep having this fragmentation and we don't have like the global framework using the same terminology, assuming the same standard regarding gender equality, and in particular online gender equality, it won't work, because then it's so tricky, the interplay between these laws, and we keep using the same recourses, which are criminal law all the time, which is of course important, but it's proving not effective. Like we are, at least for example, in Spain, where I'm from, there are more conducts being criminalized every year in a way regarding online violence, and the instances of online violence do not reduce. So maybe we have to also, apart from implementing this or not, I don't have a clear, I'm not a criminal law expert at all, but apart from that, we need to check what is the responsibility of platforms, and actually they are the ones capable of moving the messages and amplifying the content at scale. So it makes much more sense to focus on them as well.
We've just, my colleague and I who co-lead the law stream have just finished a report where we talk about that exact problem, and we kind of frame it around maybe taking a rights-based approach, so digital citizens rights-based approach, to try and frame the whole thing and bring that into. But I guess that leads on to my final question. Have we had any questions through? I think we might have. We have one, which I will go to instead of mine. So Grit has sent in and said, thank you so much for this presentation, Raquel. I was wondering what your thoughts are on the whole design of the DSA and its risk-based approach. Do you think that this managerial approach is suitable for the situative and context-based forms of digital hate and violence that are such a big factor in gender-based harms?
Can you repeat the last part?
Yes.
Or maybe I can read it because I missed.
So it's, do you think that this managerial approach is suitable for the situative and context-based forms of digital hate and violence that are such a big factor in gender-based harms?
Yeah, I think like my general intuition is that this is a good first start, and but we need to keep defining systemic risks better. We need to define exactly what do we mean, what falls in the category of gender-based violence. It's getting better and better. So, for example, to give you an intuition, at the beginning, the DSA transparency database didn't even use the same categories of violence that were included in the directive to combat violence against women and domestic violence. And then the European Institute of Gender Equality intervened and said, this doesn't make sense. Like if platforms report on gender violence and we are supposed to audit what they report and what they do, they should have at least these categories. And then they included that in in the transparency reports that platforms have to do, and also as categories in the DSA transparency database. Now they made them voluntary. So now we need to like kind of keep pushing to make it better. In a way, it's like a collective effort. I'm not sure if it should be like that, but I think it's actually sad that there are so many critiques that we can make to the DSA, but at the same time, the DSA is probably the most comprehensive framework globally to tackle technology-facilitated violence against women. So I'm really harsh on that, but at the same time, I acknowledge that this is the best we have in the world to tackle that. So, and it can also illustrate what is wrong here. If other countries are thinking of regulating in this direction, it could also inspire them to do things better or to change things. And I think this is also an important thing in this field of content moderation in general, broadly speaking, that we shouldn't be afraid to introduce innovations in the law. And maybe we will see it doesn't work as expected, and then we need to have the flexibility to adjust that through guidelines or whatever. But then these mechanisms need to be compulsory for platforms to actually respect them. And of course, I didn't talk about that, but enforcement needs to be credible. Because if platforms in a way know that there will be no enforcement, then what's the point of making everything compulsory if it's not auditable? And also the Commission itself is overworked, and the digital service coordinators as well. We have not created specific entities to control for the implementation. The same way for the GDPR, there were the data protection authorities here in most countries. The task of overseeing that is embedded into other institutions that already had a lot of work. And now on the top of that, they have more work. So, yeah.
So do you think enforcement will always equal voluntary compliance though? But I guess that you still need a sense of compliance by willingness to yeah.
Yeah, I don't know. I think for sure, probably like at this moment, I don't know what I think. I'm not sure if I can reply to this question, but I would like to believe that yes, that enforcement or aiming at investigating and trying to enforce the law would signal to platforms that they have to take this seriously. The same way that we have product safety rules in all sectors that are not the tech sector, and companies just comply with these rules, and probably it would also be more efficient for them not to comply with them. So it's like there's nothing, well, this is like the tech exceptionalism narrative, right? It's nothing that we cannot regulate and that we cannot enforce. It should be able, like we should be able to do it. Now, if we have not credible enforcement, and if the moment we were supposed to start implementing the AI Act, instead of doing so, these narratives on innovation are so embedded in even EU politics that instead of doing so, we launch a new law called Digital Omnibus to replace many of the rules, that doesn't signal clear enforcement and clear willingness of the regulators to apply these laws. And that's even more dangerous, I think.
Agreed. I'm just looking through, and I think I might make the decision to give people 4 minutes back to go make a cup of tea before their next meeting. But thank you so much, Raquel, for your presentation and answering all the questions.
Yes. Thank you.
I just want to end by saying thank you to everybody who joined us as well, and to remind everybody about the opportunity that registration for the Centre's conference is now open and can be found on the Centre's website. And hope you'll take care, and we'll see you soon.
Bye. Thank you.
Bye.